The Supreme Court. There are big conversations being had today. My understanding is that the Trump administration is not having a good time right now. If they could just end these tariffs, this fake state of emergency, that would be great. I would love to place some international orders. I found a really good French sock company recently that I'm curious to buy from, but I am not paying for the removal of the de minimis exception just to get some goddamn high quality no-show loafer socks.
50% tariff on gas-powered cars and auto parts to deal with the...
What's the brand? it's like a long French name.
Unusual and extraordinary threat from abroad of climate change.
It's very likely that could be done. Very likely.
I think that has to be the logic of your view.
Yeah, in other words, obviously this administration would say that's a hoax, it's not a real crisis, but...
I'm sure you would.
Yes, but that would be a question for Congress under our interpretation, not for the courts.
All right.
In January 2023, Congress voted to terminate one of the biggest IEPA emergencies ever, the COVID emergency, and the president went along with that. So what the statute reflects is there's going to be the ability for a sort of political consensus against a declared emergency.
Well, what happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, so Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight
with the president's assent.
Meaningful.
With the president's assent, in fact, you know.
Once he lost it by a veto-proof majority,
he doesn't sound happy.
I think the position moved, and
right.
I think he realized, and that's the political process working. There was a political
it takes a supermajority, a veto-proof majority.
Does anyone else think he sounds a little bit like Hypnos from Hades? I know that's kind of a cut, but like, no, does anyone else?
Senate, I think the position moved, and I think he realized, and that's the political process working.
He sounds like a mix of Charlie and Hypnos. Charlie Day.
There was
it takes a supermajority, a veto-proof majority.
Same voice actor. Yeah. D. John Sauer, I'm a big fan of your work. Thank you for your contributions to the projects of Supergiant games. No, yeah, he's actually the voice of Hecate. No, that's true. Give credit where it's due.
Is a highly
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would be...
you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now I think tell me if I'm wrong. You backed off that position.
Maybe that's fair to say.
Okay, all right.
That would be, I think, an abdication. That would really be an abdication, not a delegation.
This argument was insane. Yeah, it kind of sounds like he's getting his... I'm sorry, my first thought was back blown out. My second thought was make it dirtier. My third thought was, wait, that's too far. And then I just kind of got stuck in a loop for a second. Let's just go to the video.
We have been listening to live Supreme Court arguments over the authority to impose tariffs, whether President Trump has that, to impose sweeping tariffs without Congress's approval. Now, what he has been using is a national emergency law to do so. It's the linchpin of his economic agenda, these tariffs. Now, based on what we've heard, the outlook doesn't seem to be all that great for the president, who earlier this morning called these arguments and the forthcoming decision that they will make in the Supreme Court life or death. We're going to talk about what we've heard so far with an incredible panel here. Steve Vladeck, I want to start with you. What is your take on this? And again, I know we're kind of in the weeds on tariffs, but I just want to remind our viewers that this is about so much more. This is about presidential power and whether Donald Trump has as much as he thinks he does.
Let me get a non-CNN panel version of this, I think. Hold on, what is this?
Joining me now, one of those small business owners impacted by Donald Trump's tariffs, Yair Reiner, founder and CEO of Gowanus Kitchen Lab in Brooklyn and inventor of the Frywall Splatter Guard, which is manufactured in China. And you and I, Yair, thanks for coming back. We spoke in April. You said then that tariffs were killing your business.
CNN is so milquetoast on panels. You could have cut the last 2 words out there. Come on, give me a non-panel. Give me a non-panel. I don't want to watch the full 4-hour, 37-minute, 46-second C-SPAN U.S. Supreme Court oral argument on legality of the Trump tariffs. Hold on. CBS News, what do you have for me?
All right, we continue to monitor today's major case
What the
at the
fuck was
Supreme
that?
Court. Justices are hearing arguments on the president's authority to impose tariffs on any international country. CBS News legal reporter Katrina Kaufman is live outside of the Supreme Court and joins me now to talk about it. Katrina, all right, here's where we're looking. Catch us up. What have we learned so far?
Hi, Vlad. Well, first of all, I'm out in front of the Supreme Court, and there is a long line of people here who are waiting to get into these arguments. This is such a big case that it's really drawing a crowd. But so far, there has been a lot of pushback. John Sauer is arguing on behalf of the Trump administration right now, and he's arguing to a court of originalists, of textualists, of people who rely on statutory interpretation. And Vlad, they keep asking him.
No, the he's not. I hate originalism. It's not real. There's no such thing. For one, originalism is fake, and for two, it's antithetical to the desires of the founding fathers, who literally wanted the Supreme Court to be interpretable so that it can be adjusted as the times changed. Like the idea of like, well, we would only do what the founding fathers would do, in addition to being massive cope, like, yeah, as a judge, as a legal expert, my principle is that I only rule on, like, I only say stuff that's true. Well done, my love.
About the way he's trying to use the language here to regulate importation. Justice Amy Coney Barrett was pushing back a lot on him. She said, can you point to any place in the statutory code, in the history, where it was used to confer tariff authority? And she is someone who really, really is strong on statutory interpretation.
Longer segment that gets the heart of the question. Oh, I'd be willing to. Do you think you guys could stomach 7.5 minutes of C-SPAN Supreme Court discourse? Because this shit's actually super important. Basically, right now, what's on the table right now for Supreme Court deliberation is like the core conceit of the unitary executive theory, right? Basically, the whole point, I guess, like, or the whole way it's executed is you take advantage of definitional word games, essentially. Emergency situation here, extenuating circumstances here, and you give the power to the president for basically everything, If that's being challenged, that's like the fundamental conceit of the administration being challenged. If things go poorly for them here, they're going to be mad, especially with how much Trump likes tariffs.
Mr. Katyal referred to common sense several times, and I want to pick up on Justice Barrett's question, because your interpretation of the statute, as she pointed out, would allow the president to shut down all trade with every other country in the world, or to impose some significant quota on imports from every other country in the world, but would not allow a 1% tariff. And that leaves, in the government's words in its brief, an odd donut hole in the statute. Why would a rational Congress say, yeah, we're going to give the president the power to shut down trade? I mean, think about the effects. But you're admitting that power's in there.
Yeah.
But can't do a 1% tariff. That doesn't seem, but I want to get your answer, to have a lot of common sense behind it.
I think it absolutely does, because it's a fundamentally different power. It's not a donut hole. It's a different kind of pastry.
And on that power, that's a good one.
Okay.
On that power, though, and you've said this many times, and Mr. Katyal too, and look, I get this, obviously, but the court has repeatedly said a tariff on foreign imports is an exercise of the commerce power, not of the taxation power. And I'm repeating some, but John Marshall said that, and Joseph Story, and Chief Justice Hughes in the 1933 case. And we've said that quite a bit of time, which seems to at least...
I feel like that argument really loses ground when Trump explicitly says we're going to replace the income tax with tariff revenue, thereby indicating that it's not being used as a way of selectively protecting American industry, but rather just as a form of taxation. Like the idea of it being an emergency power that you're invoking for specific protections in specific cases as part of the Commerce Clause doesn't really work when he's just flat out saying, yeah, I'm doing this to replace taxation.
Undermined a bit your point that it's an entirely different power, because if it is foreign commerce power, it's the same power that Justice Barrett was talking about of just embargoing trade with the entire world, which you admit is in this statute.
Well, there are a couple of points in there, and I'll try to get to all of them, but I mean, I think all of us agree that context is what matters here, and that you certainly could use the word regulate to talk about a tariffing power, like you could use it to talk about a taxing power. I mean, we impose taxes for regulatory purposes as well. But the federal government hasn't identified a single other federal statute that uses the term regulate to authorize tariffs or taxes. That is just a different kind of power.
And I thought your point in response to Justice Kavanaugh, it's a different kind of power because the power that's being authorized by this statute is the power to control or freeze trade. That's what Congress was getting at. And so if that's true, then we have to read regulate in that context.
That's exactly right. And I think the reason, getting back to common sense as to why a legislature might authorize that, is that you might not fear abuse of that power in the same way that you would be concerned about abuse of a power to impose unlimited taxes with sort of no controlling.
Well, why is that?
Why no cams? No cameras allowed in the Supreme Court. The fact that we even are allowed to get audio recordings was something we had to fight for. The high priests do not want their divine arguments to be scrutinized.
Because, I mean, there is a sort of commonsensical intuition that one is, in Justice Kavanaugh's example, that one is greater and one is lesser. So
yeah, they're all naked in there.
Why is that not right?
Because, to be blunt about it, there's nothing, one of them there's something in it for the government and one of them there isn't. Actions that bring in revenue from the pockets of taxpayers to the Treasury pose a different set of concerns. Our framers were very concerned about that.
A different set of concerns, how, why?
Because they bring in revenue. And because that creates
well, that seems a little tautological. Like, why is it that the revenue raisers are in a different category?
Because if there is some sort of international emergency and the appropriate way to deal with it is to make sure that no more than 1,000 of this product comes into this country at a particular time, this statute gives the president the power to ensure that exactly no more than 1,000 come in at this time. Setting a tariff doesn't ensure that only 1,000 will come into this country. It cedes control over whether the transaction occurs, and what it does is it then adds revenue to the Treasury, and that is again something that our framers thought was extremely important and a core Article 1.
But Algonquin, I mean, this kind of goes back to Justice.
Who controls how tariff money is spent? If it's Trump, doesn't that steal Congress's power? It's not Trump, no. I mean, effectively, for the most part, when money is taken in via customs and tariffs and stuff, doesn't it just disappear the same way money does when it's taxed? I'm on the MMT train on this one. The government doesn't have, like, a bank account. That would be a sovereign wealth fund, which the United States doesn't really have. We don't run a profit that we would pour money into or whatever. When the money is taxed or taken in via tariffs or whatever, the money is simply annihilated, you know? It goes into the Treasury General Fund. Yeah, but, like, that's kind of it being annihilated.
Kavanaugh's point, Algonquin rejects the idea that it was impermissible to use the fees, and we can call them, license fees that functioned as tariffs or duties in that case, whatever. But Algonquin said that Congress could use the exaction of money to control quantity. And I hear what you're saying is like, well, you can control quantity by numbers by imposing hard limits, but not by money. But that's not what Algonquin said. So I guess,
no.
Why?
Well, and I don't mean to suggest that you can't use exactions to control quantity. What I think Algonquin just shows the importance of context. It might be perfectly natural to read a phrase like adjust imports in the context of a statute that talks about tariffs, in the context of the Trade Expansion Act that has all sorts of provisions about tariffs and about the president adjusting tariff rates, it might be perfectly natural in that context to read a phrase like...
Okay, try to think of it like this, okay? Imagine that instead of the government, it's an elementary school teacher. And every time a student does something good, like they answer a question well or they're nice or they share or whatever, they get a kudos. They get like a, hey, good job, okay? And the teacher gives them a little like gold sticker, not a sticker, like a little like pin, or not a, you know, like a enamel, like a little toy that's like a gold star, okay? And the teacher has a bunch of them in a desk drawer and hands them out when kids are good and they get to like have it on their desk. And then afterwards, at the end of the day, the teacher's like, okay, here you go, and takes them back in. Do you think it would be appropriate to say that the teacher is holding on to or possesses like, I don't know, 100, 200 gold stars, and that for a short time there are a few in circulation? I think that most people would only consider the relevant gold stars to be the ones that are put out, and that the ones the teacher is holding on to are just an abstract representation of what the teacher can do. Does the teacher have a maximum number of kudos she can present? What if there's a bunch of kudos given out in a day? Couldn't she just make more gold stars? The numbers she has in a drawer are kind of like irrelevant, to be honest, you know? What matters is how many are out there. Weak analogy? F you, gold name. You think hilarious analogy? The point is that the amount of money the government has is basically irrelevant because the government itself is the one that prints the money and decides, essentially, by printing it, how much it's worth, you know? The government just has to keep a ledger on how much of it is in circulation. That's their job. The point of taxation is to keep that money circulating. Same with money being brought in via tariffs. But the government doesn't have a bank account, right? It has, well, I mean, the government has like thousands of little bank accounts for various reasons, but the overall treasury is not a bank account. It's not like the government takes in $4 trillion in taxes and then they have $4 trillion sitting in the bank and then they distribute it via their programs. They produce that money. When the money's taken in, it's effectively annihilated by being removed from circulation. And then it's recirculated, but it's not the same money. It's just the concept of money. It's just a concept, you know? It doesn't have to be the same gold star. This is literally MMT. No, it's a correct principle of MMT. A lot of the other shit MMT advocates advocate for is insane, and I don't buy into it. But this idea, this concept, I believe is true.
Adjust the imports to be referring to changing tariff rates. It's just as unnatural to read a phrase like regulate importation to discuss that when the statute has nothing to do with tariffs and doesn't otherwise mention tariffs at all.
And do you think imposing tariffs is do you think that just blocking all trade is a bigger deal than imposing a 1% tariff?
Yeah, they do. It's called the Treasury. They do track it. They track it, but it's not a bank account. They have to track it to know how much money's in circulation, because the amount of money in circulation can be known literally just by knowing how much money is printed and how much money is taken in. The government is the only entity that can truly destroy money. That's why the government doesn't like it when you destroy currency, by the way, because it f***s up their calculations. If you destroy dollar bills or coins, you're f***ing up their math on how much money is in circulation. And the only amount of money, they could print an infinite amount if they wanted. They could keep those printers rolling 24/7 if they really wanted to. You know, they could put out way more money if they needed to, more coins too. It's just it's something they have to keep track of, because the amount of money that's in circulation is a function of how well they're trying to facilitate commerce.
Across the board?
I think it would be a huge deal. It is just a different kind of deal.
Algonquin was not a constitutional case, right?
Correct.
It was a statutory interpretation case.
Correct.
And so the question there was simply, was Congress actually trying to give, or did Congress in that statute give the president the authority to impose these kinds of exactions? And the court looked at the text, and it looked at the legislative history, in which there was a number of clues that Congress had actually intended to do that.
Yes, right? Yes, and it looked not just at the text of those specific words, but also the context of what else was in the statute, and the fact that some of the factors that the president...
People get confused by federal monetary policy versus state and local. Yeah, because state and local do have a bank account. Like a state government and a city government can't print money. They literally have like an amount of money they have on them. The federal government can never run out of money. All it can do is run out of how much money it's allowed to borrow, but it doesn't have to borrow that money, or in other words, destroy the money of other people by getting them to buy debt in the form of bonds. If it wanted to, the government could just go, oh, I'm going to produce infinity money to pay for all my bills. Oh, government debt? Nope, I print 31 trillion and pay it down. But if they did that, it would destroy the economy because it would break the rules about the availability of the amount of currency in circulation, you know? You don't want to do that. But like the city and the state, like the city of Seattle or New York or whatever, literally just have an amount of money they have. You know, when the city taxes, when the city raises taxes, that's an actual like literal accumulation of money, like just a regular bank account that gets put into their coffers. You know, cities can have like more or less they can save up for a rainy day just on their own. You know, they can't create the money.
Was supposed to be considering.
Keep going.
And it would make perfect sense, I think, in a time of emergency for the many of the reasons that General Sauer pointed out, that Congress would want the president to have the kind of authority that is imposed when you are embargoing things, when you are stopping the trade, when you are saying, you know, for emergency reasons, we're not letting any of this product come in. I mean, sure, that's a big deal, but the nature of it makes sense in terms of an emergency. I think what you're saying is that the idea that the government would—
the Treasury acts like a vault where money goes in and out, but it's not though, because that would imply that the government could run out of money. It can't run out of money. It's not. It's like when money goes to a bank, the money that you put into the bank isn't necessarily the money they put out, because of fractional reserve banking, the bank has the ability to literally create money out of thin air. They're given like the allowance to do it by the government, which is insane and should not be legal, by the way. All of the economy should be trading rocks for hand jobs, okay? We're getting sidetracked.
Use its authority to be raising revenues in this situation is a different kind of power.
Exactly. This is a statute about giving the president control over assets, over transactions, over access to banking.
And tariffs don't do that. You said something about
exactly
tariffs in fact cede control
exactly
over those sorts of things. So they sort of undermine the goals and the purposes of this kind of statute. Is that right?
Yes, that's exactly right.
Can I ask you?
Banks don't need government permission to do fractional reserve. I mean, they kind of do, right? Like, that's just how banking works conceptually, but they kind of do. I mean, you could theoretically do full reserve banking. Like that, the government could mandate that. It's just that because the global economic order is capitalist, we basically just accepted the idea that the purpose of banks is to make money via like loans and investment, you know? Oh.
General, just a few questions following up on the major questions discussions you've had. You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit? To lay and collect duties as he sees fit?
Duties.
We don't assert that here. That would be a much harder case now in 1790.
Isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying we shouldn't look at
fractional reserve banking is just loaning out notes representing gold that's not in the vault. Yeah, but you can't do that. The banks have the ability to effectively create money out of thin air. A bank can have $1 million, and then as people put money in, they can invest it and only have $100,000 on hand, and other people can put money in and take money out, and then you can have a situation where a bank in literal terms has a negative amount of money that they have on hand. They keep a portion, but if you take their assets versus their liabilities, they have nowhere. More money exists in hypothetical as like a combination of all the money loaned and indebted from the bank than exists in actuality. You know, it's like how a person can like sell the same share around that you can short, or you can, you know, it's possible for like the same $5 to make its way around the block a bunch. You know. Yeah, but that's something banks have done for basically over 2,000 years. I know. Wait, what were we? What are we arguing about? I thought we were talking about MMT. What are we? I know. Banking is evil.
Be concerned with. I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation.
So if the government creates money and then essentially just limits how much gets circulated, what's the point of federal taxes? Because the federal taxes are meant to circulate it. The whole point of taxes are like the money is distributed to the population to facilitate commerce and then allows people to trade. And then the government is like, you know, you don't want that money to stagnate and just sit in people's bank accounts forever. You don't want it to just, you know, like not do anything anymore. So the government has to go, you know, and slurp it back up. And then redistribute it, right? Otherwise the money gets stagnant. There's no movement of it. Also, then the only way for the government to pay its obligations would be to print new money, which would cause like hyperinflation. You know, it solves two problems. It allows for the continued like velocity of currency, while also allowing the government to settle its debts without printing, you know, theoretically printing increasing the total money supply.
Off the books, more or less.
Or
And if that's true, what would prohibit Congress from just...
That's monetary policy of the Feds, not taxes. Yeah, but the Fed can only determine its monetary policy because if the federal government decided that they were no longer going to do taxes, I guarantee you the Fed would go, what? Shit. Fuck. Like these are related institutions, you know?
abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president.
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute, again, that has a whole...
I'm not asking about the statute. General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions in non-delegation, what bite it would have in that case.
Yes, I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties, and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling.
Is this going well for us? Yeah, it seems like the court, even some of the conservative court members like Barrett, Gorsuch, Kavanaugh, and Roberts, are skeptical of some of the more extreme implications of the unitary executive theory enabling idea that the president gets to dip his balls in the soy sauce however deep he likes.
Struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale abdication of...
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply, at least.
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential...
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for.
This actually seems like a pretty good... Are there any other... Hold on. Can I get any other good C-SPAN clips from this? Like any good... Because it seems like this is actually a relatively pointed Supreme Court grilling.
Reason to accept the notion that Congress can hand off the power to declare war to the president.
Well, we don't contend that. Again, that would
well,
be...
you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now you're... I think you... tell me if I'm wrong. You backed off that position.
Maybe that's fair to say.
Okay, all right.
That would be, I think, an abdication. That would really be an abdication, not a delegation.
I'm delighted to hear that, you know.
Oh, my God.
A complete mess. I mean, you're saying before the government promised reimbursement. And then if you win, tell me how the reimbursement process would work. Would it be a complete mess? I mean, you're saying before the government promised reimbursement, and now you're saying, you know, oh, well, that's rich. but how would this work? It seems to me like it could be a mess.
So the first thing I'd say is that just underscores just how major a question this is. The very fact that you were dealing with this with quotas, there's no refund process to the tunes of billions of dollars or embargoes, but there is here. But for our case, the way it would work is, in this case, the government stipulated for the 5 plaintiffs that they would get the refunds. So for us, that's how it would work. Your question, I take it, is about everyone else. We don't have a class action or anything like that. With respect to everyone else, there's a whole specialized body of trade law, and it's in 19 U.S.C. 1514 outlines all these administrative procedures. It's a very complicated thing. There's got to be an administrative protest. There was a harbor management case earlier that this court was involved with in the United States Shoe, in which, you know, the refund process took a long time. There were any number of claims and equitable relief.
So a mess.
So it's difficult, absolutely. We don't deny that it's difficult, but I think what this court has said in the McKesson case in 1990 is that serious economic dislocation isn't a reason to do something. Northern Pipeline, you guys stayed your decision for a while in order to let the congressional process unfold. There may be a congressional process here as well. You may be able to also be that this court could limit its decision to prospective relief under the John Q. Hammonds case. So there's lots of possibilities.
That one was a little bit more wonky. A little more wonky. Brain small.
Can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase, together, regulate importation, has been used to confer tariff-imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's...
Okay, so an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power? Well, putting aside Yoshida.
I mean, obviously, the other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's
But that just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
I think our argument goes a bit further than that as an interpretive matter, because if you look at that history, the history of delegation...
Could you just answer the Justice's question?
Can you identify any statute that used that phrase to confer tariff?
Yeah, the only 2 statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA, and then now in IEPA.
And then, of course, I mean, there's a sort of direct line there.
Yeah, I understand that, but
yes.
okay.
But then more fundamentally, we rely on the historical sources to show there's this long historical pedigree of broad delegations of the foreign commerce power, not the power to tax that we're not asserting here, delegations of the foreign commerce power.
But he said he wants to use it to replace taxation. I hope one of them brought that up at some point in the 4.5 hours of deliberation.
To the president, going back to Gibbons against Ogden, all the way through McGoldrick and Board of Trustees, where this court and founding era sources say the power to, in other words, the power to tariff is kind of this natural, as everyone knows, that includes...
Just ask you one other question about the plain text, General Sauer. So you've referred to the other verbs in IEPA as capacious. Would you really describe them as capacious? Because to me, things like nullify and void have definite meanings. I agree with you that regulate is a broader term, but those words I think are powerful. They pack a punch, but I wouldn't describe them as capacious in the sense that they have a wide range of meanings. So can you describe what you mean by capacious?
Let me put it this way. You look at all 9 verbs together, and you're looking at a spectrum of powers from the most sort of negative, nullify, block, prohibit, void, to the most affirmative, direct, compel, and then also powers in between that are more intermediate, regulate, investigate, and so forth. So the natural common sense inference from that grammatical structure is the intention of Congress to sort of cover the waterfront.
Well, possible, except Congress did take out a whole bunch of verbs. It took out confiscate, vest, hold, use, administer, liquidate, sell, which were in the prior statute. And crucially, what it doesn't have here is anything that refers to raising revenue. So it has a lot of verbs, it has a lot of actions that can be taken under this statute. It just doesn't have the one you want.
Well, I would say the notion that all these other verbs are sort of not revenue raising, like block and prohibit, I think that argument is unconvincing for two reasons. One, of course, is that we don't.
Are you guys hearing the words at all, or just the voice? Because I'm not hearing much engagement with the words, only with the voice.
We're not saying it confers a revenue raising power. We're saying it confers.
Like, get it out of the way. RFK Jr., Sam Cedar. We got it? It's like half of chat.
It's a regulatory power, and that's a crucial distinction. But also...
Yes, but if I can just stop you there, regulatory power, I mean, yes, it says regulate, but I'll broaden out Justice Barrett's question. Is there any place that you can find in the entire code where regulate, used just as regulate, includes taxing power?
We don't assert that. We say it includes tariffing power when it's...
Tariffs are a tax.
Combined with importation, and that's just the most natural.
Right, because the natural understanding of regulate, even though in fact we can regulate through taxes, but when the code uses regulate, we don't typically understand it to refer to duties or taxes or tariffs or anything of the kind. And then if you look at the flip side of this, and you look at all the tariff statutes that Congress has passed, I mean, they use language about revenue raising, tariffs and duties and taxes, all the language that does not appear in the statute you rely on.
Start with the sort of grammatical structure of the statute, then refer to the other statutes. Regulate.
Is anyone agreeable to him? Is there a point where Thomas speaks up and he's like, yeah, I think that the tariffs are just regulation and not taxes at all? Is everyone here? Thomas has been silent. Okay. They're going to lose this case, man. I thought it would be a little bit more even-handed. You know, I thought that this would be, for me, this case was a coin toss. Right now, listening to it, this feels like a 95-5, you know? I feel like Thomas always, I'm saying the whole 4.5 hours.
Importation. You put those two words in combination. That's the inference from that is, you know, the founders discussed with this sort of like, you know, as everyone knows attitude, regulate importation, one of the most natural applications of that is the power to tariff. So when Congress confers the power to regulate imports, it is naturally conferring the power to tariff, which it has delegated to the executive branch, you know, again and again and again.
I'm sorry, counsel, it doesn't say regulate tariffs, it says regulate importations and exportations. You agree that they can't put taxes on exportations
from the states. Yeah, we agree with that, yes.
All right. So why should we think that it's natural then to think that regulate importation includes taxing importations?
Because that is how...
It's in the conjunctive, importations and exportations. If they can't do it with respect to exportations, why are we permitting them to do it with respect to importations?
Because as this court has recognized, going back to Gibbons against Ogden and going through McGoldrick and Board of Trustees, the phrase, when you're regulating imports, tariffing is a core application of that. So in other words, if you're saying go regulate trading and securities,
so why
that
is
come with a tariffing connotation.
Why is it that Congress has always used regulate and tax together in the code? Are you telling us that with respect to its use of regulate in other statutes, the taxing reference is superfluous? They didn't need to do that?
I'm not sure what other statutes use regulate and tax together, but this statute has a specific historical pedigree going back to its enactment during World War I in 1917, where the phrase regulate importation is evoking an inherent power to tariff that became established in the 19th century in cases like, you know, Hamilton against Dillon and so forth, and that history is, I think, set forth in Professor Baumsei's amicus brief.
Counsel.
That was a non-answer. That was a non-answer to what was basically like a devastating question. They're going to lose this. I wonder to what extent they're going to lose this. Are they going to just rule the Trump tariffs are completely illegal? That like all of these tariffs are illegal? Like I have no idea. It feels like the way he's being torn apart here, this could lead to a pretty heavy ruling against him. I have no idea. Yeah, what happens with reimbursements? Yeah, if they have to pay out tariff refunds, that's going to be like a bureaucratic debacle they're going to be dealing with for the remainder of the presidency. That's like not really possible. That would be so funny. I hope they do it. I hope they do it just to be maximally inconvenient. Yeah, the next president will be dealing with it. Gavin Newsom or whatever. Jesus. Okay, well, good news there, I guess. Really, really bad couple of days for Republicans. Really insanely bad.